Good day and welcome to another Paddocks Club video tutorial. The summer holidays are around the corner. In this video, I'll discuss the possibilities for the installation of a swimming pool in a sectional title scheme. There are three areas in which a swimming pool could be installed. The consent requirements and the considerations for the installation of the swimming pool will differ depending on the location of the pool. The pool could either be placed on unregulated common property, in an exclusive use garden area, or on a balcony, patio or strip that is part of the section. In the first place, the installation of a swimming pool on common property would be considered an improvement to common property that's not reasonably necessary. Prescribed Management Rule 29.1 requires the authority of a unanimous resolution of the body corporate to make such an alteration or improvement to the common property. An important consideration would be the potential liability from the use of the pool on the common property for the body corporate. In terms of Prescribed Management Rule 23.6, a body corporate must take out public liability insurance to cover the risk of any liability that it may incur to pay compensation in respect of death, bodily injury or illness, or loss of or damage to property occurring in connection with the common property, for a sum of liability for an amount determined by the members in a general meeting, but not less than 10 million rand or any such higher amount as may be prescribed by the minister. In addition, the body corporate must make sure that the whole area is maintained and that any defects are repaired so it does not present any danger. It is important that the pool complies with local municipal requirements with regard to fencing and general safety, because Section 3.1p of the Sectional Title Schemes Management Act states that the body corporate must ensure compliance with any law relating to the common property or any improvement of land comprised in the common property. The body corporate should also consider placing a sign warning users and occupiers and any of their visitors that they should use the pool at their own risk. Furthermore, I would recommend a conduct rule that requires children must be supervised by an adult or a guardian at the pool area. In the second place, Prescribed Management Rule 29 does not apply when an owner applies for the installation of a swimming pool in their exclusive use garden, because the body corporate is not initiating or paying for this improvement. When an individual owner proposes to install a swimming pool within the confines of their exclusive use area, the decision is one taken by the body corporate by ordinary resolution in terms of Prescribed Management Rule 30G, which states that the body corporate must take all reasonable steps to ensure that a member or any other occupier of a section or exclusive use area does not construct or place any structure or building improvement on an exclusive use area, which in practice constitutes a section or an extension of the boundaries or floor area of a section, without complying with the requirements of the Sectional Title Schemes Management Act and the Sectional Titles Act, provided that the body corporate may, by ordinary resolution, 1. Give consent for such a structure or building improvement if they are satisfied that it does not require compliance with such requirements. 2. Prescribe any reasonable condition in regard to the use or appearance of the structure or building improvement. And 3. Withdraw any consent if the member or other occupier of the section breaches any such condition. In the third place, there is no provision in the Sectional Titles Act or the Sectional Title Schemes Management Act or the prescribed rules that deals directly with granting permission to an owner to install a pool within their section. There are, however, provisions that could be used to prohibit an owner from building a pool. In this regard, Prescribed Management Rule 30D states that the body corporate must take all reasonable steps to ensure that a member or any other occupier of a section or exclusive use area does not make any alterations which are likely to impair the stability of the building or the use and enjoyment of other sections, the common property, or any exclusive use area. The pool should not be aesthetically displeasing. In this regard, Prescribed Conduct Rule 5 states that an owner or an occupier of a section must not, without the trustee's written consent, make a change to the external appearance of the section or any exclusive use area allocated, unless the change is minor and does not detract from the appearance of the section or the common property. The pool should not negatively affect other owners and occupiers. In this regard, Prescribed Management Rule 30E states that the body corporate must take all reasonable steps to ensure that the member or any other occupier of a section or exclusive use area does not do anything to a section or exclusive use area that has a material negative effect on the value or utility of any other section or exclusive use area. Therefore, before granting consent for the installation of a swimming pool in an exclusive use area or within a section, the trustees should consider how it would affect the rights of other owners and occupiers. The trustees should make absolutely sure that they know and take into account all the possible consequences before consents are given. In this regard, Section 13(1)(e) of the Sectional Title Schemes Management Act states that an owner must not use his section or exclusive use area or permit it to be used in any such manner or for any such purpose as shall cause a nuisance to any other occupier of a section. Private pools definitely increase the value of properties, but they also increase the amount of noise generated and the amount of water used. A swimming pool is a permanent feature that might today be used by a retired couple who are quiet and careful, and next year by a family with 3 young children who make a substantial amount of noise. Apart from the possible noise, it must also be considered whether the owner will pay for the water used in the pool and whether that water source is separately metered. It must be considered whether granting permission is a sensible move, in particular case and for the scheme generally. The point of departure must be to do what is best for the scheme as a whole. If the trustees agree to one swimming pool, they may be opening the door to all owners wanting to have a swimming pool. It could even be necessary to call a general meeting of owners to allow the matter to be properly debated before the trustees make up their minds. Owners could even choose to give the trustees a direction in terms of Section 7(1) of the Sectional Title Schemes Management Act as to how to treat this type of application. I also recommend a conduct rule that codifies how swimming pool applications should be treated, the type of conditions that must be set, that will ensure separate metering of water consumption, and that will set the rights and responsibilities of the owner concerned, the immediate neighbors, and the body corporate as a whole. Thank you for watching this video. Should you have any questions, please post them on the discussion forum.